Begin with day 2 of the Supreme Court confirmation hearings as lawmakers on the 22-member Senate Judiciary Committee started their questioning of Judge Jackson.
Among the many topics, she was asked about her past cases and her judicial philosophy. CBS News correspondent Skyler Henry has more from Washington.
On day 2 of her confirmation hearings, U.S. Supreme Court nominee Ketanji Browne-Jackson said her judicial philosophy is to be impartial and interpret the facts of each case.
As a judge in our system, I have limited power, and I am trying in every case to stay in my lane.
She also noted the importance of diversity on the High Court as the first black woman nominated.
It supports public confidence in the judiciary when you have different people, because we have such a diverse society.
Senate Republicans have characterized Judge Jackson as soft on crime and questioned her past sentences in child pornography cases.
I made sure that the victims, the children's perspectives were represented, and I also imposed prison terms and significant supervision and other restrictions.
During questioning, Judge Jackson said the First Amendment applies to conservatives and liberals equally. The Second Amendment is a fundamental right, and landmark rulings regarding abortion are settled law. But she refused to weigh into the conversation on whether the court should be expanded, calling it political.
I believe that judges are not policymakers.
The president watched portions of Judge Jackson's hearing yesterday and today and is proud of the way she is showcasing her extraordinary qualifications.
The White House says President Biden is receiving regular updates on the confirmation hearings. Skyler Henry, CBS News, Capitol Hill.
For more on today's hearings, Gloria Browne-Marshall joins us now. She's a professor of constitutional law at John Jay College of Criminal Justice and the author of the book She Took Justice: The Black Woman, Law and Power. Professor, welcome. Thanks very much for being with us. From the questioning we've heard so far, what is your general assessment of each party's approach to these hearings?
Well, I'll say that the Democrats seem to be offering up not just a shield, but I think a more general explanation, giving the Judge Jackson more time to explain her answers. And the Republicans, of course, I think are feeling a little vengeful after Judge Kavanaugh's and Amy Coney Barrett's nomination hearings. And so they're trying to score points and try to take revenge using Judge Jackson. And so they're raising certain very important issues. For example, her decisions around the child pornography cases, as well as her work as a public defender and representing those detainees at Guantanamo Bay. So each answer she gives, she's not allowed to say but so much, but then the Democrats come back and give her a chance to try to give more clarification on her answers and why she decided her cases the way she did.
Yeah, Professor, I want to pick up on some of the Republican lines of questioning. Senator Lindsey Graham, he voiced a concern that's shared by many in his party about what the role of a judge is. Let's take a listen.
What is your judicial philosophy?
So I have a methodology that I use in my cases in order to ensure that I am ruling impartially. And that,
so your judicial philosophy is to rule impartially?
No, my judicial philosophy is to rule impartially and to rule consistent with the limitations on my authority as a judge. And so my methodology actually helps me to do that in every case.
So you wouldn't say that you're an activist judge?
I would not say that.
Now, Professor, we all know that a president picks the nominee, but it seems like we're at a point where a judge is often referred to in the context of who nominated them, kind of indicating some kind of potential bias. When did the phrase activist judge become so commonplace in these types of hearings?
Well, being an activist judge has been around for quite some time. If you think about going all the way back to Justice Brandeis, who was considered an activist judge because he was considered a person who was for the laborer, for the little people. And so the pejorative activist judge came about, I would say, in the last 20 years with the idea that liberals are somehow activists and conservatives are not. When, of course, we had Donald Trump ask for a list of judges who could be those who would overturn Roe versus Wade and actively participate in a political agenda of the mindset based on the president who nominated them. So activist has become a pejorative in the last 20 years or so. If you think about Thurgood Marshall was an activist and an advocate in civil rights, but it wasn't seen as a negative back then. It was seen as part of the job. You represented your clients as best you could and tried to make good law for your side of the case. But now it's seen as something very negative, and that's why it's being used that way by Senator Graham.
And Judge Jackson was also asked about the concept of court packing, an idea floated by some Democrats to increase the number of Supreme Court justices. She said, quote, "It's a policy issue for Congress." Professor, you are a professor of constitutional law. Help us understand here, who has the power to decide the size of the Supreme Court?
Well, that's the issue. In the U.S. Constitution, there is no size given for the court. And so sometimes the court has been larger and it's been smaller. And so at this point, what we're trying to see under not just President Roosevelt, who came up with court packing, but also today with Joe Biden, is whether or not people can have better decisions coming from a court that has a more diverse makeup. But as I clearly think, and others have too, that if you extend the court today for your own mechanisms or means, it's going to be extended for the next president and the next party as well. So I don't think it's a very good idea. Congress now is thinking that it wants to participate in making the court permanently 9 members. But presidents have tried this before and they'll try it again. The Supreme Court has already ruled under the time period of President Roosevelt that court packing is unconstitutional.
And Professor, it seems like we've seen a lot of these hearings in recent years, and that's because Judge Jackson would be the 8th Supreme Court justice to ascend to the High Court since 2005, if she's confirmed. So how have you seen the confirmation process evolve in recent years?
It's become a political football because there's such division between the parties. They use now these hearings to throw spears at each other and try to score political points and also to firm up their base. So instead of actually asking questions of the nominee, they're asking these questions with the idea that the base is going to be, appreciative of the type of zealousness that they're using, if they're conservative ideals or liberal ideals. So they're feeding meat to the lions in many ways and then using the nominee as bait. I think also it's become less about the qualifications of the nominee and more about what that nominee might do in the future. Because they sit for life, you could have someone, as Justice Breyer's been on the court over 40 years, have that much of an influence over generations of people. And that's why the power is not in just the fact that she would be a liberal, so-called liberal judge. The power is going to be at some point, there's going to be a tilt in the court in which those liberal justices are going to have the majority, and then how will they rule? That's the consideration. And I think conservatives think generationally. Liberals probably think more about next election. And so that president who has the opportunity to put a Supreme Court justice is not thinking about their political legacy today. They're thinking about the political legacy for generations to come.
All right, Professor Gloria Browne-Marshall. Professor, thank you very much for sharing your insights with us.
Thank you.